Hello friends, welcome to my channel. It's a girl Mercy. If you're a returning subscriber, I appreciate you. If you're new here, please keep watching this video. Subscribe to this channel, like the video and share it. So today I'm going to talk about how to move a bail application part 2. I've already talked about it at the part 1 series. You can check my channel, the Lawyers Infohub, for that video. So today I'm going to look at how to move a bail application part 2. In my other video I talked about what happens or what's obtainable at the magistrate court. So today I'm going to talk about what happens at the high court. Now, first of all, you have to also understand that where an application for bail is refused at the magistrate court, you can also come to the high court to make that same application. But in making that same application, you have to attach the CTC of the ruling of the magistrate court refusing the application and the CTC of the charge, in your application to the high court. Now, in this instance where your application at the magistrate court has been refused and you bring it to the high court to be heard. Now, if it's in the south, you expect it to be in the form of summons. If it's in that north, it has to be by way of motion. Just like a motion, the summons you heard it, summons for bail, after you must have listed out the parties. Remember that the accused will also have to be the applicant, because you're bringing, it's more like a motion, you are praying the court for an order, so the accused will be the applicant. So you state the parties, you now summons for bail, you now say let all parties be heard on the before court so and so of the high court of the state, for the hearing of the application, admitting the accused applicant to bail. It's similar to a motion. So you look out for summons for bail and fit in your prayers as such. Then in a normal motion, you list out the parties. We also remember that the accused also be the applicant. Then you heard it, motion on notice. You have to bring it portion to section 36 of the Constitution, and depending on your jurisdiction, if you are using the CPC or the CPA, the relevant section of those laws. Now, your prayer in your motion should be an order of the Honorable Court admitting the accused applicant to bail. Then you do the omnibus ground, which is an order for further or other orders the court might deem fit to make, depending. Now, you have to also state the grounds upon which your application, you're bringing it. So further take note that the grounds upon which this application is predicated on as follows. Now, you now list the grounds upon which you're urging the court to admit the accused to bail. Remember that when your motion or a summons for bail, you have to attach an affidavit in support and a written address wherein you have canvassed the points upon which you ask the court to grant bail to the accused. Now, remember in your affidavit, you have to list out, you have to now expatiate those grounds you're relying on in the paragraphs of your affidavit. Are you relying on the height of the accused? You have to state it in your affidavit, but your affidavit must be in line with the Evidence Act. No opinions, no conclusion, and the rest. Now, you have to. Are you retaining the accused the first time offender? You have to state it there. Are you stating that that the accused will not interfere in police investigation? You have to state it there. Is a bail? You have to state it there. Is hypertensive? Is this? Is that? You have to state all there, in your affidavit in support of your motion or your summons. Now, in your written address, you now expand on these points and bring in cases that supports your argument, so that are persuasive to the court, that the court will look at and admit the accused to bail. Now, there are factors the court considers in either to grant or to refuse bail whenever investigation comes to the court, God looks at certain factors that he considers, which you as a lawyer will have to also put in mind. You have to also factor it in your own application, depending on which one is peculiar to your circumstance. Now, before a court can grant bail or refuse bail, the court will have to look at one, the likelihood that the accused, if granted bail, will not distort or affect the police investigation. Where the court is of the view that if I release the person on bail, it will distort police investigation, it will jump bail, will not be available, and all of that, the court will refuse the bail. Now, the health of the accused is paramount. If counsel, the accused can persuade the court, or there are reasons to see, yes, this person has this health issue, you attach the medical report in your affidavit in support, and it's okay, my lord, this person is this, look at his health. The court can see the certificate, the medical report with respect to the disease you are claiming this person has. Then it can also be persuasive. So the court will look at the health of the accused in either to refuse or to grant bail. Another one is the nature of the offense and the severity of the penalty. Remember that in capital offenses, it's difficult for bail to be granted. Not that it's very difficult, because all those offenses that carry the death sentence, or life imprisonment, is already difficult for the court to grant bail. Rarely, court granted rarely, unless in this circumstance too, the court will also look at the charge and the evidence in support of the charge that has been presented by the state or the commission of police in the whatever instance as pertains to that case. So the court looks at the nature of the offense and the severity. This will also guide the court's mind as to whether to grant bail or to refuse. Now, the court also look at the prevalence of the offense. If the offense is such that it's regularly committed in that state, the court will be like, no, I'm not going to grant bail. For example, we are in the era of child abuse. We have pedophiles, and all of that. So if it's a case of that, the court will be like, no, if I let this one go or release this person temporarily, we will go and continue to abuse children. So the nature and the prevalence of the offense also is the determinant factor for the court to either grant or refuse bail. Now, the list is not exhaustive, but these are major things the court will look at. Will this person be available to attend his trial? If granted bail, will this going to distort the police investigation, the health, the nature of the offense, the severity of the penalty, and the health of people? These are also factors the court considers, in deciding whether to grant bail or not. Another very important thing is the antecedents of the accused. If just like I was saying earlier, that in your grounds under your motion that the accused is the first-time offender, is also a ground. This is now where the court look at the antecedents of the accused. This accused, is he a known criminal? Is this someone that is well known, as has maybe other charges before that is still facing trial that is facing? So the court looks at the record of this person. Is he a first-time offender? Is he a known criminal? No, I can or I cannot grant bail. So these factors are very important. These are what the court considers, irrespective of whatever the circumstances are. Now, as a lawyer with distinction, as a lawyer with excellence, you have to research and bring in cases that are peculiar to the circumstance. Bring in cases that are peculiar to the circumstance and move the court. In moving your motion for bail, like normal motion, my lord, before my lordship is a motion on notice dated the day this day and filed this day, my lord, the motion is brought pursuant to section 36 of the Constitution, and depending on the jurisdiction, if it's CPA or CPC, table section, this is of the CPA or these are of the CPC, depending on which jurisdiction you're practicing. And my Lord, the motion is praying for an order of this honorable court to admit the accused applicant to bail. My Lord, we have stated 6 grounds in this application, which are the grounds upon which this application is premised. My Lord, we have 17 paragraph affidavit in support of this application. My Lord, in paragraph 6, 7, 8, 9, 10, we have highlighted the factors. We have highlighted issues of, we have highlighted points, my Lord, that is peculiar in this that is peculiar for the court's consideration with respect to this application. My Lord, there are 3 exhibits, my Lord, attached to the affidavit, and my Lord, we have there's a written address in support where we have canvas forms, my Lord, to show, my Lord, that the accused can be granted bail. It's within the court's discretion. Remember, the granting of bail is within the discretion of the court, which has to be exercised judicially and judiciously. So you pray the court and you move the court where we have started plethora of cases. Then, my Lord, in our written there we have canvas points to show that, my Lord, this honorable court is empowered to grant bail to the accused. So that we have, you have move the application and you have let's say you have covered points, that to your advantage for your client. So you urge the court to grant your application. Remember that the prosecutor normally want to oppose, or depending on the circumstance, it doesn't matter. So you also look at the points the prosecutor or whoever is on the other side for the state or for the police is presenting. If you have case laws, to reply, very important, you reply them. If you don't, you leave your application as that, and now leave it at the discretion of the court to either grant the bail or refuse it. But whichever way, the court will also give reasons for whichever action it wants to take. So moving an application at the High Court with respect to bail is easy, it's simple, it's something you can do, and I know that these little tips will help you, to go through it and come out successful. Please keep watching this channel. I want to hear your feedbacks. I want to see them at the comment section. Hit the subscribe button if you have not subscribed. Share this video because I know it will help someone out there. Thank you. I remain your blessed. Thank you very much.